Thanks very much. It's really a thrill to be in this wonderful, beautiful, historic hall. So as you can see, this is a very short introduction to a very big subject, the U.S. Supreme Court. It's not the kind of book that an author is going to do a reading from. It's not a dramatic novel, but it's a pretty dramatic story, actually, when you step back and think about the Supreme Court over the centuries. And I know many of you are probably here because the Supreme Court today, this very day or next week, 3 days of the healthcare case being argued, the court is more visible in American life than it's been for quite some time. And I'll be happy to chat about that and answer to your questions, but I want to talk a little bit and just kind of frame the story of the Supreme Court. In writing this book, what I tried to do was put myself in the position of, I'm assuming, many of you or myself before I had the chance to attend Yale Law School and spend the next 30 years writing about the Supreme Court on a daily basis for the New York Times. And that is to say, somebody who's interested in public affairs, interested in the civic life of the country, but just doesn't happen to be an expert on this particular topic. So what would a person like that, a person as I was, and maybe some of you are, need to know to really get a personally satisfying handle on the court? So with that as a kind of framework, what I propose to do is really make a series of observations that I'll elaborate on and then turn it over for what I expect will be a fruitful and fun conversation among us. So when you step back and think about the court, one thing that jumped out at me as I was organizing the material to write this book is the extent to which the Supreme Court is really the author of its own story. It wasn't given very much to work with. I mean, I said I wasn't going to read, but I'll read the first sentence of Article 3 of the Constitution, which says, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." And that's kind of it. The Article 3 goes on and talks a bit about the jurisdiction of the court and so on, but many, many unanswered questions, including, for instance, there's no mention of the Chief Justice in Article 3. We only infer that there's supposed to be a Chief Justice because he's given in Article 2, the presidential article, the right to preside over, or the duty to preside over the impeachment trial in the Senate of the President of the United States. And remember, William Rehnquist did that in the Bill Clinton impeachment trial. And when he was later asked what it had amounted to, he said, "I did nothing in particular and I did it very well." So the duties of the Chief Justice are undefined. And much about the Supreme Court initially was undefined. So it really had to create itself. And it's done so not in a straight line progression, but it's done so through its cases. The cases that in the early years it had to decide because it had very little discretion over what to hear, and the cases these days that it chooses to decide. And even that was a choice by the Supreme Court. You know, most appellate courts today in this country, they have to take what comes. And so they act sort of as courts of review, courts of appeal, courts of error correction. And that was the Supreme Court's initial fate, or so it seemed. But William Howard Taft, the capstone after his presidency was becoming Chief Justice of the United States, and he sized this up, and he thought the court would greatly benefit from the ability to write its own ticket, create its own docket, not have to take every case that came along. So under his leadership, his urging, Congress passed in 1929 what's known as the Judges' Bill, because all the judges of the country got behind this effort, and gave the court, for the first time, discretion over its docket. And so that's the place we are today. We have a Supreme Court that is capable of and does set its own agenda. And in doing that, it really sets the legal agenda for the country. And when you think about it, that's really a very powerful tool that members of the court have, especially if there's a majority of 5 of them, in projecting their own legal agenda onto the canvas of the country by means of the court's docket. I mean, just one example, and it's not healthcare. The healthcare case, really the court, I'd say, didn't have too much discretion as a practical matter in deciding to resolve the dispute over whether Congress had the authority under the Commerce Clause to create the individual mandate, because the lower courts were in dispute over that. So when you have a federal law that a federal court of appeals has declared unconstitutional, that's almost certain to be granted review by the Supreme Court, even though as a technical matter the court doesn't have to take it. It would have been really, really surprising had the court not chosen to take that up this year with the lower courts in disarray. But I'll give another example of a case that the court didn't have to get into at all, and you may not have heard much about it yet because it won't be argued until next fall. But the court is getting back into the business of deciding the constitutionality of affirmative action in higher education admissions. And you might say, huh? What's that about? Remember in 2003, when the court upheld in the Grutter case the affirmative action admissions plan at the University of Michigan Law School, and Justice Sandra Day O'Connor, writing the majority opinion in that case, said, okay, this is a tough issue, but we've decided it, and as far as we're concerned, it's now resolved for the next 25 years. We hope in 25 years from now, affirmative action in higher education won't be necessary, but that's it, we're finished. Well, so this being, my math isn't that good, but I think it's about 9 years later, we find the court having undertaken to review affirmative action admissions at the University of Texas. And that's a case that's going to be argued early next fall and decided sometime in the spring of 2013. And it's an example, I mean, it's obviously 5, let's assume 5 justices, some of whom were not on the court back in 2003 when the court decided the Michigan case, who were not happy with that outcome and have decided that they're going to get their hands back on it. And so I think the threat there is something that can really unsettle something that's been fairly well settled in much of the country up until now in these last 8 or 9 years. And that's an example of the power that the court has to get us thinking, talking, responding to issues that come framed as legal, constitutional issues, basically whether we want to or not, the court's agenda-setting function. So one thing that I have found intriguing over the years in watching the court and the behavior of the justices is, how do they know what they know, or how do they know what they think they know? How do they know what the country wants, what the country needs? What are the facts at their command? They lead lives that are not as isolated as many people assume. They live in their own homes, they drive their own cars to work, and they have the same sort of upper middle class daily lives as many other people. But they are at least somewhat isolated, and the court doesn't have the ability to send fact finders out across the land and try to come up with a better understanding of the reality behind the cases that they undertake to decide. There's one example from a few years ago, 2008, that just struck me as really exemplifies the vulnerability that the court has in a situation where it's really the captive of the information that people, the parties, the friends of the court in their briefs bring to it. And that was a case from Louisiana, a case called Kennedy against Louisiana. And the question in that case